Hello and welcome. My name is Sanders Legier. I'm the CEO and co-founder of Carbon Hound, and we're really excited for today's Cut to the Chase webinar with Alicia Panu. So we're getting a lot of questions about the new anti-greenwashing provisions of the Competition Act. And so, well, what better way than to bring an expert in to tell us a little bit about what's going on and why it's important. So Alicia is a senior associate at Osler's Competition and Antitrust and Foreign Investments Group. She advises clients in all aspects of competition law, including merger review, abuse of dominance, greenwashing, and compliance matters. And in her foreign investment review practice, she advises clients on national security, net benefit, and culture society reviews under the Investment Canada Act. Now, interestingly, she previously worked at the Competition Bureau, where she reviewed high-profile mergers under the Competition Act, which is exactly what we're going to be talking about today. She was named as one to watch, very exciting, by Best Lawyers. She serves in leadership roles in both the Canadian Bar Association's Competition Law and Foreign Investment Review section and the American Bar Association section of Antitrust Law. Okay, that's a whole mouthful, but basically she's incredibly credentialed and we're very lucky to have her. So thank you very much for making the time, Alicia, and looking forward to learning more about how these new provisions are going to impact Canadian businesses.
Thank you for having me, Sanders. I'm very excited to chat about this topic of the anti-greenwashing provisions of the Competition Act. Obviously, very topical right now and as front of mind for a lot of businesses. So in terms of what we'll be discussing today, I thought we'd start by discussing the state of play of Canadian competition law and enforcement approach as it relates to greenwashing. And then we'll discuss the new provisions that are specifically aimed at combating greenwashing, which have been sort of the topic of interest for everyone. And then we'll discuss the recent release guidelines from the Canadian Competition Bureau that describe their enforcement approach or their planned enforcement approach as it relates to environmental claims. And then we'll turn to best practices for mitigating risk to ensure that you're not offside any of these provisions. We'll do a short little sort of summary overview to kind of recap what's discussed, and we will leave some time at the end for audience questions. So at a high level, as I thought it would be kind of helpful to give a lay of the land in terms of what's sort of prompted these amendments and interest by the Competition Bureau in greenwashing. So over the last number of years, consumers have become increasingly environmentally conscious. They're seeking out products and services that are represented as clean, green, sustainable options, and they're looking to a business's track record on being environmentally friendly when they're making purchasing decisions. So in response, what we're seeing in the marketplace is that businesses are taking note, and many businesses are promoting themselves and their products with environmental claims. This trend is something that's not unique to Canada. It's taking place around the world. And so what we're seeing, what's accompanying that is that there's now also interest in going after some of those bad actors that are making untrue environmental claims relating to their products and services or business practices. So, Europe, US, Australia, and Canadian securities regulators, competition law enforcers, and private parties have been increasingly active in tackling greenwashing and bringing regulatory actions and class actions for damages against businesses. And so more in Canada, the Competition Act is one of the laws that comes into play when these environmental representations or claims are misleading or unsubstantiated. And this has been the situation for decades. While there are greenwashing provisions that have specifically been introduced, and that came into force last year. The deceptive marketing provisions of the Act have captured environmental representations or claims as well. We'll touch on that in a bit more detail. So as you may have heard, the Competition Act has been significantly overhauled over the past few years through a series of significant amendments that were passed between June 2022 and June 2024. So for the purposes of today's presentation, there's three main changes to the Canadian Competition Act that we wanted to highlight. First, there's two new sections that were added to the civil deceptive marketing provisions, which are tailored to combat greenwashing. The second is that starting last month in June, private parties are now able to bring actions under most of the civil provisions of the Competition Act. So that includes the deceptive marketing provisions, the greenwashing provisions, against other private parties. So prior to this amendment, only the Commissioner of Competition could bring an application to the court under the deceptive marketing or greenwashing provisions of the Act. So they had a monopoly, but starting this past June, we'll see enforcement from not just the Commissioner of Competition, but also from private parties going after bad actors. And then the third significant amendment under the Competition Act that's of relevance for our discussion today are the penalties for non-compliance with the greenwashing or deceptive marketing provisions has substantially increased. So the stakes are now much higher. And what you'll see is the good part of it is, there's going to be increased interest in ensuring for business in ensuring that they're not offside the provisions. And there is obviously a lot more at stake for businesses in terms of what they can lose from a monetary perspective. So that all goes to say that these changes really underscore the importance of compliance with the Competition Act's deceptive marketing regime. So there's a wide range of deceptive marketing practices that are covered by the Competition Act. But for today's purposes, there's three main areas to focus on. One of which is there's provision under the Competition Act that prohibits any representations that are false or misleading in a material respect. The second is the prohibition against unsubstantiated performance claims. And the third is the new greenwashing provisions. I'll touch on each of these in more detail. I guess one small thing that's worth noting is for the first and second type of provision, so representations that are false or misleading in a material respect or unsubstantiated performance claims. The first representations that are false or misleading in a material respect can be pursued both as either as a criminal offense or a civilly reviewable offense, but whereas the second and the third type of provisions are only civilly reviewable. For the purposes of this presentation, we'll focus on the civilly reviewable enforcement. Criminal enforcement is very rare under the deceptive marketing provisions. It's really pursued for only the most egregious type of conduct. So beginning with the general prohibition, the Act prohibits anyone from promoting a product, service, or business interests through claims that are false or misleading in any material respect. So there's two main elements to this, whether the representation is false or misleading. and whether it's false or misleading in a material respect. So representation is, I may be very obvious, but it might be worth explaining. It's a broad term that encompasses virtually any form of communication. So it's not just words, it also encompasses words, images, oral statements, product advertisements, or corporate disclosure records. So to determine whether a representation is false or misleading, the Bureau will consider not only the literal meaning of the representation, but it'll also look to the general impression it conveys to consumers. So the general impression conveyed takes into consideration the text, images, and sounds of the advertisement. It's not limited to what is explicitly said. In terms of materiality, a representation is false or misleading in a material respect where the claim could influence consumer behavior, such as a decision to purchase a particular product. So if a representation has absolutely no impact or bearing on how a consumer behaves, then it would not be considered a representation that's false or misleading in a material respect. So that's also important to keep in mind. Following these recent Competition Act amendments, any claims that are made about environmental matters will always be considered material, which is significant. So the Competition Act, as I mentioned, also deals with performance claims. So performance claim is any statement regarding the performance, efficacy, or length of life of a product. It is a subset of representations. So for example, a claim about the health benefits from supplements, cellular network speed or reliability, claims made about a product being, recyclable, emissions efficiency claims. Those would all be considered performance claims. So what the Competition Act requires is that where a performance claim is made, it must be substantiated by an adequate and proper test. So what will constitute an adequate and proper test will depend on the context. So for example, what product is being marketed. But generally, the test must be conducted before the performance claim is made. It cannot be done after the fact. The test must be conducted under controlled circumstances to eliminate external variables. The test must eliminate subjectivity as much as possible. It must reflect the real-world usage of the product and support the general impression created by the representation. Turning now to the more recent general provisions that were added, the greenwashing specific provisions. So under these new provisions, businesses bear the burden of proving that on balance, any performance claim that they make about a product's benefits for protecting or restoring the environment or mitigating the environmental, social, and ecological causes or effects of climate change is based on an adequate and proper test. They also bear the burden of proving that any representation that they make with respect to the benefits of a business or business activity for protecting or restoring the environment or mitigating the environmental and ecological causes or effects of climate change is based on adequate and proper substantiation in accordance with internationally recognized methodology. So the phrase in terms of the second bullet there, so representations with respect to benefits of a business or business activity, the reference to internationally recognized methodology caused a lot of consternation and public discord. regarding the amendments when they were first introduced, because the term was left undefined. So it created a lot of uncertainty. But the Competition Bureau, thankfully, in their guidance that they released early last month, explains what the Bureau, the Canadian Competition Bureau, views as internationally recognized methodology. So I'll touch on this in a bit more detail later, but it's not as a little bit of a sort of a sneak peek. It's not as rigorous as some businesses had feared that it may be. So it's worth noting at the end of the day, the amendments to the Competition Act do not represent a significant departure from what was already the law in Canada. The same type of claims that will be targeted under the new provisions could likely have already been targeted under the general prohibition against false or misleading representations, or the prohibition against unsubstantiated performance claims. What's, I guess, different is it is now somewhat easier for an applicant to succeed with their claim, but the law is really quite similar. So here on this slide, I've highlighted some key observations about the new greenwashing provisions, or some key takeaways for you all. So first is that the amendments, as I mentioned, reinforce existing law about the need to have adequate testing or credible substantiation for claims that were made to the public. Environmental claims should be consistent with the most recent evidence and methodologies of independent organizations with well-recognized expertise in the field. Second, the new amendments put a premium on disclosure. The onus of proof now lies with the company that's making the claim to demonstrate that there is a substantial benefit to disclose. Because of this, there's now a substantial benefit to disclosing the substantiation sources that provide support for the claim. While it's only required to be produced when challenged at the tribunal, disclosing these sources could help ward off applications in the first place. And then lastly, the existing due diligence defense for other deceptive marketing provisions also applies to these new greenwashing provisions. So if a company or organization can show that it exercised due diligence to prevent the misrepresentation or unsubstantiated performance claims from occurring, then it will not face an administrative monetary penalty. The only sort of penalty that it may face is a prohibition order telling it to stop making those representations or performance claims, which is significant because under the Competition Act, the tribunal court can impose an administrative monetary penalty of up to the greater of 10 million for a first offense, or 3 times the value of the benefit derived from the deceptive conduct, or if that amount cannot be reasonably determined, 3% of the corporation's revenues for that year, which is quite significant. So I thought it would be helpful to just walk through an example of environmental claims. First, to show an example of a claim about the environmental benefits of a business or business activity that would not be based on adequate and proper substantiation in accordance with internationally recognized methodology. So in other words, it would be offside the Competition Act. So the scenario here is a business in the agriculture sector has been working hard to reduce nitrogen runoff from its farms into nearby water bodies through precision fertilization, cover cropping, and improve soil management practices. the business is aware of another farming enterprise growing different crops in another province that uses similar but not identical techniques to also reduce the nitrogen runoff from its farms, which claims that they have done testing and measured that they reduced nitrogen runoff from their farms into nearby rivers and streams by 70%. Instead of conducting its own testing, this business decides to make the same claim as the other farming enterprise, relying on the belief that the reduction in nitrogen runoff is likely to be similar. So this claim by this hypothetical farming enterprise would likely to be offside the Competition Act. It wouldn't meet the threshold of needing to be based on adequate and proper substantiation in accordance with international recognized methodology. Here we do, like, the business has no sense of what methodology was used by the other farming enterprise. It's also the farming enterprise is also using similar, but it's not using identical techniques. So it's not really it's not an apples to apples comparison. They're growing different crops. So it's also a very different scenario, could result potentially in different results. So it would not meet the Bureau's threshold. And it's worth highlighting what's considered adequate and proper in the Bureau's view requires that the substantiation be suitable, appropriate, and relevant to the claim, and sufficiently rigorous to establish the claim in question. And often this will require substantiation that is scientific in nature. And third-party verification will be required in circumstances where it's called for by the internationally recognized methodology relied upon for adequate and proper substantiation. In the second scenario here, it's the same business, farming enterprise. They have the same goal of reducing their nitrogen runoff. But what they decide to do instead is the company follows these ISO 5667-1 and ISO 5667-6 to measure. So measure the nutrient concentration in streams directly downstream from its managed fields, both before and after the practices were implemented. The measurements showed a 50% decrease in nitrogen runoff from the managed lands. And based on the study, the company makes the claim that over the past 5 years, we have protected the environment to reduce nitrogen runoff from our farms into nearby rivers and streams by 50%. So here, the Bureau would likely consider the representations to be statements about the products performed, or to be statements that are based on adequate and proper substantiation in accordance with the internationally recognized methodologies. Here, the company is following these ISO methodologies. They're measuring, they're doing the testing themselves. They're measuring before and after. They're limiting external variables. So they're unlikely to be offside. So now that we have quickly run through the key greenwashing provisions, I thought it would be helpful to talk about how those provisions are enforced by both the Commissioner of Competition and the Bureau, as well as by private parties. So under the Act's civil deceptive marketing provisions, there are a wide range of civil remedies that are available to the court or tribunal. The tribunal can prohibit the reviewable deceptive marketing conduct, require the publication of corrective notices to the public regarding the conduct, or impose significant administrative monetary awards. As I briefly mentioned earlier, these monetary penalties were significantly increased as part of the amendments to the Competition Act in June of 2022. So where a party is found to have engaged in civilly reviewable deceptive marketing conduct, the tribunal or court can impose monetary penalties of up to the greater of 10 million for the first order or 15 million for each subsequent order, and 3 times the value of the benefit derived from the conduct. In cases where the benefit derived from the conduct can't be reasonably determined, the maximum penalty is 3% of the annual worldwide gross revenues. And as you can imagine, these can lead to some very significant administrative monetary penalties.
Alicia, sorry, just a quick question. So when you're talking about those penalties, they're very significant. So is it because it sounds like there's 3 different options, if you will, of how you can get fined. Do they pick the one that's the most expensive, the least expensive? Like, how do they choose which one of those is applied?
Yeah. So in terms of the option between 3 times the value of the benefit derived from the conduct, or 3% of the gross revenues is only in factor if they cannot determine 3 times the value of the benefit derived from the conduct.
Okay.
In terms of choosing between the 10 million and on one hand, for let's say it's the first time offense, and 3 times the value of the benefit derived, to the extent that they can determine that. Between those 2 options, they will choose whatever is the greater penalty, essentially.
Okay.
The greater one between the 2.
So that means that you're paying at least that, was it 10 million or
10 million at minimum? Yeah.
Okay.
Yeah.
Big number.
Yeah. So, and then it's also worth noting that for violations of the general prohibition against materially false or misleading representations, the tribunal or court can also order the party to pay restitution to those who purchase the products at issue. And this remedy is only available for the 2 new greenwashing specific provisions.
Wow.
Yeah. So as part of the amendments that went into force last summer that brought about the greenwashing provisions, the Competition Act was also amended to expand private enforcement of the Act, including with respect to deceptive marketing practices. So starting June 20th of last month, private parties are now able to apply for leave from the Competition Tribunal to bring an application for remedies under any of the misleading representation provisions, including the 2 new greenwashing specific provisions. Leave will only be granted to private parties if the tribunal determines that the case is in the public interest, but it's unclear how the tribunal will interpret this public interest test. How the tribunal interprets this test will be significant because it will be the mechanism that's used to screen what claims can proceed to a full hearing on the merits. So while these new amendments to the Competition Act expanding private enforcement have created significant excitement, it remains unclear whether this change will open the door to like a wave of new private litigation. Okay, I'm going to jump to the next slide, cognizant of the time. So I'll just touch on some of these examples quickly, but it's worth noting that even prior to the introduction of the new greenwashing provisions to the Competition Act, there was already significant and high-profile enforcement actions relating to environmental claims. For instance, The Bureau did an investigation into Keurig, the investigation about their claims relating to the recyclability of their single-use coffee pods. The investigation ultimately resulted in a consent agreement between the Competition Bureau and Keurig. As part of its settlement, Keurig agreed to pay a $3 million penalty, donate $800,000 to an environmental charity, change its claims and packaging, and publish corrective notices. There was also a high-profile case against Volkswagen and Audi 2016, and resulting from 2016 and 2018 Bureau investigations relating to their emission standards. The companies had to pay significant monetary penalties to the government, and there was also class actions resulting, follow-on class actions that stemmed from this that led to the companies agreeing to a settlement worth up to $2.39 billion just in Canada alone. So very, very significant.
And the Keurig example, they only got fined $3 million. So in the new world, that would be minimum 10 then, so that they got off easy, if you will.
Yeah, it was pre-amendment. So I expect that even where there is a consent agreement between the Competition Bureau and private parties, the settlements will be for higher amounts, because the alternative litigation, at minimum, the Bureau or the companies would be subject to $10 million in penalties.
Okay.
So now that we've covered the various deceptive marketing provisions and how they apply to greenwashing and the basics of how the provisions are enforced, I wanted to chat about the Bureau's guideline on environmental claims, which just came out last month. To understand public enforcement of the Competition Act, guidelines are a very helpful tool because they give us insight into how the Competition Bureau is thinking about these provisions and what are their enforcement priorities and the types of cases that they're likely to bring under these provisions. So as I mentioned, on June 5th, just early last month, the Bureau released the final form of its enforcement guidelines. These guidance represents the Bureau's interpretation of the law and views on how to enforce the provisions in the public interest. But it's worth noting that neither private litigants or the Competition Tribunal are bound to follow the Bureau's guidance. But while the tribunal is not bound to the Bureau's guidance, it may be considered when they may look to it when they're considering an application. So this slide here touches on 6 general principles that are set out in the guidelines for businesses to follow when making environmental claims. So they're pretty straightforward. The first is that environmental claims should be truthful, not false or misleading. Second, the environmental benefit of a product and performance claims should be adequately and properly tested. Third, comparative environmental claims should be specific about what is being compared. Fourth, environmental claims should avoid exaggeration. Fifth, environmental claims should be clear and specific, not vague. And sixth, environmental claims about the future should be supported by substantiation and a clear plan. This last point is particularly important for businesses to keep in mind, as many environmental claims can tend to be about the future. So I'll revisit this in a bit more detail in a moment. So some key aspects of the Bureau's guidelines that I want to highlight is that the Bureau is focused on marketing representations. So when enforcing the deceptive marketing of provisions, the Bureau's focus on representations that are made in marketing and promotional materials. The Bureau is not focused on representations that are made for a different purpose, such as to investors and shareholders in the context of securities filings, which is certainly worth noting. Second point, key aspect I wanted to highlight was, which I've kind of touched upon already, is what is considered adequate and proper substantiation in the context of claims. So substantiation should be suitable to the claim and sufficiently rigorous. It should be consistent with recent evidence and practices, and it may call for third-party verification where required by the chosen methodology. And then in terms of the Bureau's guidelines are helpful because they explain what they view as internationally recognized methodology. So the Bureau's guidelines state that they will consider a methodology to be internationally recognized if it's recognized in just 2 or more countries, which is not a very high bar to meet. So the methodology does not need to be recognized by the government of those countries. It can come from a variety of sources, such as standard-setting bodies, regulatory authorities, or even industries or other entities using methodologies that are commonly accepted internationally. And the methodology does not need to be the best methodology that is available. To the extent that a methodology is recommended by a government program in Canada, the Bureau's guidelines state that they assume that it would accord with internationally recognized methodologies, but businesses should still exercise due diligence.
Is this more of a spirit of the law versus letter of the law situation in terms of, like for example, I know the GHG protocol particularly was referenced as an example in the guidance. So does that mean that we can assume that appropriate application of the greenhouse gas protocol would be accepted?
Yeah, it would. I think it's very safe to assume that the GHG protocol would be considered internationally recognized methodology.
And I guess same thing for science-based targets or SBTI?
Yeah.
Okay. So when making the net zero claims, that's probably more appropriate in that case.
Correct.
Okay, great.
So I guess relevant to what you just said, the guidance from the Competition Bureau on forward-looking environmental claims is critical, particularly because of how commonplace these representations are. They're often made in the context of emissions reductions or achieving carbon neutrality by a set future date. Even if a business has the best of intentions when setting these targets, when they're presented to the public and marketing, they need to be able to back it up. So the claims need to be properly substantiated, accompanied by a concrete, realistic, and verifiable plan to fulfill the claims, and meaningful steps in furtherance of that plan should already be underway. Just gonna jump forward, but the Bureau's guidelines do touch on new technologies as well and what to do if there's no methodology that's yet been developed to test for the new technology. So we've touched a little bit on the net zero claims. So I'll talk about the substantiation for claims that are not required to be publicly disclosed. So the party making an environmental claim must, if challenged, be able to demonstrate that it's properly substantiated. However, supporting information does not need to be made publicly available, but there are, as I mentioned earlier, benefits to publicizing the substantiation. It can demonstrate the truthfulness of your claims to consumers and or competitors, thereby reducing the risk of litigation.
Yeah, I also feel like there's an element here of may not be legally required. Like you're going to have the information anyways, and you're going to have to, substantiate this that anyone challenges on you anyways. So,
Yeah,
you might as well get credit for the homework that you're doing and be transparent with how you went about addressing these claims and substantiating these claims.
exactly. If you're already doing the work, you might as well publicize all the work and due diligence that's been done to support the claim. And from a marketing perspective, consumers tend to look upon businesses that are forthcoming in their practices a bit more favorably.
Yeah, like even us, we were looking at buying a screen for one of our offices. We're going on the websites of all the manufacturers, and the ones that had actual reports and data were definitely ones that we were considering much higher than the others.
Mm-hmm. So, I mean, this is quite obvious, but based on given the public interest in greenwashing and the amendments that have come about, greenwashing is certainly an enforcement priority of the Competition Bureau. So we can expect to see more bureau enforcement on greenwashing that there has been in the past. And even regardless of that, we can expect there to be private litigation, given that there's new private right of access that was just introduced on June 20th. So that'll be sort of another avenue of enforcement and where we'll see some activity.
So a quick question on that, Alicia. Do you note that have we seen any precedents before where private action has been added as an enforcement mechanism, I guess would be the term. But I'm just curious, like, have we seen any demonstrated examples where that significantly increases the amount of litigation in this space?
So under the Competition Act, there's been under most of the provisions of the Competition Act, the Commissioner of Competition has had a virtual monopoly on enforcing the act. There's very, very limited provisions where there was a private right of access, and they were provisions where there was generally very little enforcement, even from the Commissioner of Competition. This sort of introduction of a private right of access is very recent. The first new private right of access that was introduced was abuse of dominance. That was introduced in 2022, and there's been a few cases that have been introduced under abuse of dominance. Obviously, the threshold there for showing meeting the test for abuse of dominance is significantly higher than green deceptive marketing, which any company in theory could engage in if they wanted to. Abuse of dominance requires a business to have significant market share, so only few companies can even engage in that.
Right. And theoretically, due to the size of some of these potential claims, there could be more incentive for lawyers and organizations to bring litigation.
Exactly. Yeah. I recognize that we're pretty short on time, so I don't know if we had questions. Anyone can feel free to pop in questions at any point in time, and I'll address them. But in the meantime, I guess, Sanders, I'll continue on with the last few slides.
Yeah, I mean, I've got a couple questions maybe we could touch off. I think these best practices are really important. So maybe if you want to cover those quickly, and then we can jump into a couple of the other questions we had.
Sounds great. So this slide just outlines some recommendations that I would have on best practices to mitigate the risk of greenwashing allegations and reducing exposure for litigation. So the main focus is really on ensuring accuracy, transparency, and legal defensibility in environmental claims and governance practices. So, first best practice is obviously making sure your environmental claims are appropriately calibrated and substantiated. They should align with the latest evidence and methodologies that are endorsed by independent third-party organizations with a recognized expertise in the field. To the extent that you're making a claim with respect to reducing carbon emissions, set realistic and achievable targets, and have specific strategies and timelines in place for emissions reductions and other goals. You want to avoid statements that overpromise on environmental outcomes, performance, and benefits, or overstate the impact of carbon offsets. You really want to focus on direct emission reductions achieved through operational changes and innovation. And as we mentioned earlier, it would be a best practice to include the substantiation source and maintain not just accurate, but very detailed substantiation records to respond to any challenges that you might receive. Sort of relatedly, you want to carefully document any due diligence that you undertake to support environmental claims, given that there is a due diligence defense. The fourth point is kind of hard. Yeah, I feel like I've touched on that quite a bit already, so I'll skip over that. And then fifth, you want to develop internal processes to assess environmental claims and involve legal counsel in drafting and reviewing environmental representations.
Okay. Awesome. Thanks, Alicia. Okay, so we got a quick question from Jennifer just about, will we receive a copy of the presentation? So yeah, we will be releasing the recording of this, so you'll definitely get that. A couple quick questions that we had, maybe you can or can answer some of them, but I guess the first one was, obviously there's a lot of companies out there, it's on their vans, it's on their, you name it, saying, oh, eco-friendly or green or sustainable, kind of like very high level, like, oh, we're a green company, or we're a sustainable company, or we care about sustainability. Would those be considered claims, or like how does that get treated in terms of that generic language that we often see companies making?
That's a great question. So in terms of, making a very broad over brushstroke representation as to being green, I think it does leave, it kind of goes to the general impression test. So to the extent that a challenge is brought to the competition tribunal, the tribunal would say, what is the general impression that's conveyed here? Would an ordinary consumer look to this and make certain assumptions about the product or the business practices of the company? Would they assume that they recycle or do this or that? It definitely creates some sort of general impression that they're engaging in certain environmentally friendly practices. And so it would certainly open the company up to litigation or enforcement, where they are making claims that could be left open to interpretation and they're not able to back it up.
Okay. And so if I'm, let's say I'm outside Canada and I'm selling into a ship into Canada, am I impacted by the same regulations?
Sorry, you're a company operating outside of Canada?
Yeah, but then I'm maybe selling into the Canadian market. Maybe I'm shipping products there. Would that impact my business as well?
Yes, that would. So Audi and Volkswagen are two examples of companies that don't necessarily make their cars in Canada, but they were certainly didn't impact the Competition Bureau's ability to enforce the provisions of the Competition Act, where they engaged in deceptive marketing.
Okay, and last one. I know you don't have a crystal ball, but based on your experience and any historical points that we can look at that might be similar, what do you foresee the impact of all these changes will be practically in the market?
Yeah. So in terms of what I foresee, there's certainly a lot of interest or from businesses, or I don't know if concerns are the right word, but they want to make sure, given the stakes are so high in terms of the penalties that are available, for being offside these provisions, businesses are, are wanting to make sure that they are mitigating risk, that the Commissioner of Competition or a private party can go after them for making misleading representations. So my crystal ball, if looking into the future, I think more companies will make sure that they are substantiating their claims. It'll weed out the bad actors, which is good news for all the companies that are doing this in a very legitimate and thoughtful way, and it's part of their business ethos. So I think this is a good for the marketplace. It's good for consumers as well, and that they can kind of have a bit more trust that where claims are made, that they're more likely to be true, like accurate. But yeah, so
Okay.
that's kind of,
And we had one more here. So obviously Volkswagen, big company, right? Is this something that just big companies should be worried about, or is this something that can impact small businesses as well? And maybe reflecting a bit on your time at the Competition Bureau as well, like who can get caught up in this? Do small companies need to be as worried as big companies?
small companies are not immune to enforcement of the Competition Act. Certainly with bigger companies, they have more eyes on them, frankly, so that they're more likely to, the Competition Bureau is more likely to receive complaints about, where there's, bigger companies are engaging in bad practices. So, given the impact that there would be from enforcement, the Competition Bureau is certainly more likely to take on those cases, and of course, they're more likely to receive complaints. Private parties might have more of an incentive to go after the big companies, given that the rewards can be so much greater. So I think we'll continue to see more targeting of the bigger companies, given that there's more impact, more potential for bigger rewards, monetary rewards. But that's not to say that smaller companies are immune. In fact, these provisions also, they apply not only to small businesses as well, but they also apply to nonprofits or trade associations as well. And the Competition Bureau has investigated, these industry groups as well that have been, coming up with some of these like certifications, which the Bureau thought maybe weren't legitimate, and has gone after them as well. So it's not just big companies that are being that need to make sure they're on side the provision.
And given you got the unique insight of maybe working some of these organizations, do you find that most of these complaints, or like are most of these enforcement actions triggered by complaints versus them actively going out and seeking specific situations where there might be issues?
In terms of public enforcement by the Competition Bureau, they don't have eyes and insight into everything. So there is to a certain degree, reliance on intelligence that comes from the market, complaints that come directly to you. But the Competition Bureau does also, and its officers do also do some proactive enforcement, and they'll go and look around and scour, company websites, and they'll do their own market intelligence as well and look into company practices, or what, cases that they think, might be good cases to bring, essentially.
Very cool. Okay, well, look, I know we're over time a little bit. Want to be respectful of your time as well, but I really appreciate you coming. Is there anything that you wanted to finish off on?
Um, well, it's been a great discussion. This is obviously a sort of an evolving area, and we expect, I think everyone's in this space that practices law in this space is eager to see what particularly private litigation will see coming forward, given that that's sort of the most recent development in this area. The private right of access is just, you know, and the penalties have been available since June 20th. So to the extent, the stakes can be high given the potential for significant monetary penalties. If anyone has any questions, I know sometimes when you get into the nitty gritty of the actual representation or claims that want to make, it can get a bit nuance. So to the extent anyone has any questions, feel free to reach out to me. We'll circulate this deck. I know there were some slides that we kind of had to run through pretty quickly, so we'll make that available to everyone following this webinar.
Amazing. I think we didn't really specifically talk about it, but I think one important thing to note is that this isn't regulation that's happening in the future. It's already in place today. So something that we should be thinking about immediately. We just have a bit more detail in terms of how it's actually going to be enforced now. But I believe the initial changes for this were made last year, right? And now we've got the final guidance. So now we really need to take a look at the claims that we're making and ensure that we're on the right side of that. And I'm really excited about this only because I feel like it's horrible when you do all of this work to do good and do well, and then you don't get rewarded for it, or you get rewarded for it at the same rate that somebody who is taking a lot of shortcuts and isn't actually doing the work is getting rewarded. So I really hope that this continues to build a stronger business case for climate action and doing the right thing and the sustainable thing, rather than and making that more and more aligned with increased profit margins and better business outcomes. So thank you so much thank you so much for your time, Alicia. Really appreciate you coming in and sharing your expertise. As she mentioned, we will be sharing the slides and the recording of the presentation. We're also working on a one-pager, so we'll get that out when it's done. Yeah, thanks again for joining us, and hope